Hello, everybody, and thank you very much indeed for coming. So I'm going to talk about grey belt. And so start off, what is it? Well, I think we're all fairly familiar with the definition by now. Three key aspects to note. Firstly, one gateway to grey belt is PVL. The second is land that doesn't strongly contribute to purposes A, B or D. And then there's the exception in circumstances where the application of policies related to footnote 7 areas and assets would provide a strong reason for restricting development. And of course, we must remember the definition applies to the land, not the development. So Gateway 1 PDL, a familiar definition, a couple of things that are worth bearing in mind. It's the words in brackets in the second and third and fourth lines that you don't assume that land within curtilage of developed land should be developed. Have been there for a long time. But of course, when you're looking at whether it is or isn't PDL, thus qualifying for grey belt status, those words in brackets don't matter. So that if anything that is within the curtilage of developed land, subject to the exemptions below, is in principle capable of being grey belt land. If you've got a degraded land, maybe some former kennels site, for example, or some other sorts of sites which may have been developed in the past, but are I can't think why I said kennels. I noticed some muttering over there. But where the use is long discontinued, make sure you trim the grass. Make sure that you don't allow the land to the previous development to blend into the landscape. Second gateway, which is the one that's proved probably most interesting over the last year or so, land that doesn't strongly contribute to purposes A, B or D. Most importantly, a contribution to C doesn't count for this purpose. And I'll put the three relevant greenbelt purposes here. The PPG, published in February, made clear that villages aren't built-up areas, and once that's taken into account, it becomes clear that land around a village can't strongly contribute to purposes A, B or D by definition. And post the Court of Appeal's judgment in the Mead case, we know that the PPG can set policy and not just merely guidance that sits below the NPPF. So one should treat the PPG on grey belt as having the same status as the NPPF. The effect of that PPG on villages can be seen from the Castle Point decision earlier this year, in relation to which Inspector Burnham, whose decision was upheld by Mrs Justice Leven a few weeks ago, he noted that Dawes Heath in Castle Point was a village, and therefore axiomatically it qualified as grey belt. I would expect, in light of that, as local authorities cotton on to this, and indeed parish councils as well, what we may see over the next year to 18 months is sustainability and settlement character impact objections being put forward by objectors, by local authorities, in place of greenbelt objections, to try and effectively re-argue the same point through a different prism. You may also potentially see the savvy neighbour plan authorities defining their village. Dunny-on-the-Wold suddenly becomes a town as opposed to a village. It's rather ironic, isn't it? The people you often find at planning inquiries, people would say, we are a village, our identity is all the village. They see that as a badge of honour. And now they're having to put that to one side. So no, we're a town. So watch this space. They're judging the contribution to greenbelt purposes. Well, the PPG provides the rubric. I'm sure many in this room, like me, have advised a number of times on the application of an interpretation of that rubric. Critically, the real divide in most cases is the distinction between the strong category in the PPG and the moderate contribution category. In most instances, to qualify as a strong contribution, you have to have all the features listed in the guidance, as opposed to just some of them, and that tends to be where the dividing lines are. Sasha's amazing career-defining victory in the Marlowe Studios case a few days ago is indicative, though, that there are limits, because in that case, even the inspector had held that there wasn't a strong contribution to the relevant greenbelt purposes. The Secretary of State made a point of disagreeing. The critical points, those in Bowles' site, isn't clearly defined to the east and south, and the development would be an incongruous pattern. The footnote 7 proviso, we discussed this on We Got Planning News for you a few days ago. The South Staffordshire decision of Inspector Coffey a few days ago held that even though the parties in that case agreed that heritage harm wouldn't be a strong reason for refusal, and indeed wasn't a reason for refusal advocated by anybody, it was a strong reason for restricting the development because the development was in the setting of a listed building, and on that basis the site wasn't grey belt land. That seems to contrast with the Marlow Studios decision, where having found that the development in question would have an adverse effect on the setting of national landscape, as well as the setting of various heritage assets, leading to concomitant policy conflicts, nonetheless, the application of the policies in footnote 7 wouldn't provide a strong reason for refusing or restricting, and therefore the site wasn't taken out of the definition of grey belt on that basis. So difficulty reconciling those two decisions. I understand there's a case pending before the High Court related to a truck stop, which ought to resolve this one way or the other. My view is the Marlow Studios decision is the preferable approach. Turning then to paragraph 155. So once you are grey belt, what do you need to do to take advantage of paragraph 155 in order to be appropriate development, therefore not require very special circumstances? Well, 3 by now quite well-known tests. Assuming it's grey belt land, next question is, would it fundamentally undermine the purposes taken together of the remaining grey belt across the area of the plan? There must be a demonstrable unmet need for the type of development proposed, and it must be in a sustainable location. Turning into 155A, what does not fundamentally undermine the purposes taken together of the remaining green belt across the area of the plan mean? Well, the so far limited thinking from the Inspectorate and Secretary of State on that limb is that it's a very high bar for the local authority to surmount in order to resist development on 155A grounds. Another Studios case, Greystoke Lands failed appeal in Windsor and Maidenhead. The Secretary of State's approach was that the development would leave the overwhelming part of the green belt remaining in the local plan area, and on that basis 155A wasn't failed. Now, that's a very high test indeed. I mean, absent something, of a sort of Heathrow Airport HS2 type scale, pretty much any development is going to pass that test, I would have thought. So we then turn to paragraph 155B, demonstrable unmet need. In relation to housing, and for what it's worth, gypsy development, there were clear metrics in relation to housing, a sub-5-year housing land supply or sub-75% of the housing delivery test over the last 3 years will automatically trigger the existence of a demonstrable unmet need. But what about non-housing development, for which there's no metric? How do you go about proving that for employment, commercial, industrial, data centres, etc., that kind of development? Well, from my own experience of an inquiry on this issue earlier this year, the Lignocite case, there were 2 dimensions to this. Firstly, how do you demonstrate the need? What sort of metric do you create? And secondly, what's meant by the type of development proposed? So in that case, to demonstrate the need for a service yard next to a blockworks that was providing about 44,000 homes worth of building blocks in the southeast, what we do is have company evidence from the company, say this is what we need to do, this is what we propose to do, this is what it will achieve in terms of output, additional blocks, etc. And then economic evidence to say objectively this is why it won't just benefit the company's private interest, but why it will actually assist the public interest by delivering the following knock-on benefits in terms of GDP, productivity, cutting supply chains, etc. So that would be my general approach in any such cases, company evidence plus objective evidence, but aim for why this is in the public interest. And the type of development, the local authority said, well, the type of development for which that be demonstrable unmet need was B2 or B8 generically, and we had an awful lot of other kinds of B2, B8. Even if you have your particular need for extending the blockworks, that wasn't enough. And the inspector had none of that, subject to a condition tying the development to block production. The type of development was the actual type of development, block production, not the generic use class. So consider that approach in future cases. I turned into the golden rules. I was struggling to come up with an image of the golden rules. And when you're struggling for anything, I always default to Bon Jovi, the greatest rock band that ever lived, with whom at least one of you in this room is coming to see them at their triumphal return to Wembley Stadium next year. I did think about buying one of those gold suits for this presentation. So the first golden rule. John Bon Jovi, your lead vocals. Why is he the first golden rule? Well, the first golden rule is a default 50% affordable housing. And what is 50%? Halfway there. I'm here all week. We fairly formulate the first golden rule, a 15 percentage points above the highest existing development plan affordable housing requirement with a default 50%. In its absence, note the bold text. We were told back in December that there'd be PPG on viability to assist in circumstances where 50% wasn't viable. Will we see that before Christmas? I wonder. Second golden rule, Bon Jovi have been missing their necessary infrastructure in the form of Richie Sambora since he departed the band in 2013, much to my immense regret. But what necessary improvements to local infrastructure or national infrastructure should developments meet to satisfy the second golden rule? Or does it actually add anything to what was the case before anyway under SIL Regulation 122, that it's long been the case, since probably before I was even born, that an application for planning permission stood or fell in terms of Section 106 contributions to local infrastructure by whether the obligations in question were or were not necessary to make the development acceptable. So is the second golden rule something beyond that, or is it really a restatement of the status quo? So far, the thrust of the appeal decisions in the last year seem to be it's simply doing what you have to do in order to for the development to consume its own smoke in terms of infrastructure, as opposed to going further than the SIL 122 test. That seems to be the position, but not yet tested, actually, in a controversial case. There's a man who's played a few open spaces in his time, and the third golden rule relates to open space. David Bryan, I'm not lying, as said. And the third golden rule, green space. So critically here, there are two aspects, actually, if one looks carefully to the text. The provision of new or improvements to existing green spaces that are accessible to the public. So pausing there, there has to be provision of green or improvement of green spaces that are accessible to the public. And then it goes on to say new residents should be able to access good quality green space within a short walk of their home, whether through on-site or off-site spaces. So what about, for example, a situation where there is on-site private green space which the residents can use as well as off-site accessible improvement? Does the on-site green space have to be publicly accessible? No, it doesn't. It's only the improvements in the first sentence that have to be publicly accessible. The green space that the second sentence refers to for new residents has to be available to them. It doesn't necessarily have to be available to the others. That and other points were tested in Beechcroft's appeal success in relation to land at Wilton Park, which I was involved in, where the inspector gave Beechcroft a Valentine's Day present on the 14th of February, allowing the appeal. And there was on-site green space provision in the form of it was largely a care home and later living development, on-site provision in terms of the green space within the courtyard and the landscaping around the development, and then off-site provision in the form of that particular development enabled a land swap, which would now allow a off-site football pitch development to commence. It already had permission, but it wouldn't have proceeded but for this consent, and there were relevant conditions involved. So you can have a combination of off-site and on-site. What are the consequences of complying or not complying with the golden rules? Well, we know that where there is compliance with the golden rules, paragraph 158 says significant weight should be accorded to it in favour of the grant of permission. Had I got a photograph of Bon Jovi's drummer, Tico Torres, in a gold suit, which I couldn't find on the internet, that would have been the photograph out of fairness to him, given that his drumming carries significant weight. I spent a long time looking for that image to no avail. So to get the benefit of paragraph 155, the grey belt gateway to being appropriate development, you have to comply with the golden rules. And if you don't, then you won't be appropriate development and VSC will be required. However, if you're not relying on the 155 gateway, for example, in the Wilton Park case, the site in question was judged to be PDL, so it benefited by 154G. If you don't have to rely on 155, then it's not strictly essential, because if you, for example, your 154G appropriate PDL development, then there's not an NPPF paragraph 11D1 strong reason for refusal. And then the compliance or non-compliance with the golden rules goes into the application of the tilted balance under 11D2, assuming that you're in a tilted balance situation, and it will go into the planning balance if not. So there may be some instances where one can not comply with the golden rules, but a miss may not be as good as a mile if you're not relying on paragraph 155 in the first place. And I put that passage there. So without further ado, I shall now pass over to Thea to tell you about renewables.